Hi, and welcome to Moving Towards Justice. This is part of AEquitas's Foundations of Sexual Violence series. I'm excited to talk about pretrial litigation and how to effectively use it to enhance our prosecutions. We at AEquitas are here to provide you, through the generous support of our federal funding partners, innovative, informed, and hopefully really practical strategies for you to be doing this, sort of challenging work that you're doing day in and day out. We do that through various, methods, one of which is to create resources like this and other recorded resources that live on our website. We have a lot of public-facing webinars, as well as written resources and statutory compilations. We often will provide training on large and small scales across the country. We're involved in a lot of partnerships and initiatives. One of the ones I'll highlight because of the topic of this series is the Sexual Assault Kit Initiative. We're proud to be one of the TA partners for that. And we also provide, and I think this is probably our favorite thing to do as attorney advisors, consultation. So that's one-on-one opportunities to reach out to AEquitas, talk to one of the attorney advisors here at AEquitas, and maybe soundboard a particularly tough case or ask for some specific resources that you're needing. You can follow us online. We have a number of social media platforms, so whatever you're comfortable doing professionally, it's a great way to stay up to date on ongoing opportunities for training or resources that we push out. And we are supported in our work, especially today, through the Office of Violence Against Women. We want to thank them for their support. Of course, it doesn't mean that everything that we say today is necessarily reflecting their views. So, and lastly, because we like to be innovative and bring things to you from others, from other experts in the field, we'll often cite or acknowledge their work, and we do that under the fair use doctrine. So we'll get started. I'm Jane Anderson. I'm one of the attorneys at AEquitas, and today I have the privilege of speaking with one of my colleagues, John Wilkinson, as we talk about pretrial litigation. So John, if you don't mind giving everyone a little bit of an introduction.
Hey, Jane, thanks for having me. I'm John Wilkinson. I'm an attorney advisor at AEquitas as well, and work on these cases along with Jane. I'm a former assistant Commonwealth's attorney from Fredericksburg, Virginia. We're a small office. I always like to present with Jane because we're kind of the opposite side of the same coin. So there were 4 prosecutors in our office, and so you did every kind of case, from traffic offenses to first-degree murder. But I focused a lot on domestic violence, homicide, sexual violence cases, and I was on our sexual assault response team, which was kind of game-changing for me and just sort of made me better understand how these cases work closely with the partners that work on these cases, become more educated about it, and then hopefully respond in a better way and have more success across the board. So that's sort of my background.
And he says that because from his office of 4 people in Fredericksburg, Virginia, I came from the prosecutorial office in Miami-Dade County, where there were 250 of us. And I started my career doing only domestic violence cases for a year. And that was me and like 24 of my colleagues, and that's all that we did. So quite a bit of a difference, but hopefully together we can share our experiences, because these cases have a lot of commonalities, and wherever you are, you're going to be wanting to do things to, improve your ability to be successful and hold offenders accountable. And one of the things that you need to do, and I'm sure you'll talk a little bit more about it, but that SART and that collaboration. But what that does in part is allows us to analyze our cases better and think about in advance of trial, like what are our issues that we're going to need to deal with, and how do we do that pre-trial so that we're going to be set up for success, and we're not trying to brief judges on new or novel issues that they don't see every day. We don't want to be doing that in the middle of trial. We want to brief them in advance and make sure that they have the time and opportunity to do the research and make a really informed decision that hopefully, of course, is aligned with our position. So we'll talk about that. We'll talk about discovery and other evidentiary motions that might promote victim safety, victim privacy, and all those things that help us help allow the victim to participate and feel more safe in the process. So why is motion practice, John? And I know I think that I got better at it the longer I was in the office, and I realized like this is game changing when you have the time, hopefully, to implement a strong motion practice.
Yeah, no, I agree. And I think about like your work in sexual assault cases and human trafficking cases. Human trafficking in particular probably drove a lot of your motions practice, whereas I feel like typically we were more responsive and not proactive. And turning the page where you become more proactive about these motions, you take advantage of some of the things that the motions help with. Just understanding what evidence is going to get into trial so you can strategize better about how I'm going to make this case go forward. Or maybe that's the thing that makes the defense plead because they were hoping to keep something out and now they know, nope, it's coming in. And so they have to reassess their case. So there's just all sorts of advantages to being proactive in a motions practice and making it part of your routine response to these cases rather than a piecemeal response in an unusual case. We want to be doing a lot of these things in every case.
You're so right. And, previewing the case for the defendant who's now maybe going to take a plea because they realize we've done the work to, find maybe in sexual assault cases, find other victims, find other cases that can support that. So we're previewing it for the defendant, but also for the judge. I think sometimes they're trying cases in a vacuum. Maybe they've seen like the four corners of an arrest. In our case, just like a very simple arrest form, and they're not really seeing anything else. And then it comes to the trial, and for the very first time, they're thinking about, a particular aspect of the defendant's control or premeditation. And if they have a little bit of a preview, we're probably going to be the beneficiary of those in-trial rulings.
Yeah, no, I agree 100%. It also gives us the ability, I think, to lay the foundation for what the arguments should be, rather than have them sprung on a judge at trial. And the defense is going to then have the opportunity to characterize the arguments. And I want the judge to be thinking about them the way they should be thought about, or I think they should be thought about, and laying out those things. The novel issues are so important because I just think judges want to make sure the defendant has a fair trial. The victim also has the right to a fair trial. And so we want to make sure that that's on the mind of the judge. And so putting out information about how a novel issue should be decided is going to be super important so that the judge doesn't make a reaction that's just, oh, it's close, I'm just going to go with the defendant because I want to make sure they have a fair trial, or I know the defendant isn't going to appeal a ruling in their favor. So that could be, what drives that close issue. Whereas if we lay out the novel issue, and not just novel issues, right? I think when you say preview the case for the judge, just laying the foundation for the law that governs these particular issues is important so that they're making very current, informed decisions about what the legal landscape is and how it applies to the facts in each of these cases.
Mm-hmm. Because we might have a specialized practice. When all I did was domestic violence for a year, I became a bit of a little expert on domestic violence cases. And then throughout my career, I would handle felony domestic violence cases, but those cases, we weren't in a specialized courtroom. Those cases, that judge could have just come from a rotation in probate or civil. And I don't know if you even had more than one judge in Fredericksburg, Virginia, but they don't necessarily have that background that we maybe assume that they have.
Yeah.
And so you're doing a little education and you're not trying to do it while they're worrying about the jury being right outside, or, we're not doing it in a pressure cooker situation. We're letting them take it back to their chambers, talk to their colleagues, have that time to really be thoughtful.
Yeah, no, I think that's such a great point because I think I got stung many times making assumptions about the judge, we had 3 judges in front of.
Oh, like it was like
So-
a one-on-one.
No, but it was, the felony circuit court judge who did all our sexual violence cases. We had a couple of misdemeanor sexual violence charges, but they were mostly all felonies. Our general district judge, who handled all misdemeanors and preliminary hearings, and then our juvenile and domestic relations, which is our DV court judges, who tended to have more of that education on these issues, both domestic and sexual violence issues. And so you make assumptions because you're typically appearing before that judge who has a little more education about it. And then you get stung suddenly making an assumption. It's like, oh, that's not how this works. Even if it's a misdemeanor bench trial, I know you guys didn't have really bench trials. It's all jury practice down there, but we had a lot of bench trials. And so you do have to strategize about how you're going to educate that fact finder, whether it's the judge or the jury. And you do it in different ways depending on those circumstances. Motions practice is a great way to do that, and judges appreciate that. I think that, it's just funny. Like one of our best pastimes in Fredericksburg was to come back from court and complain about a judge's ruling. It's just like, because it didn't go our way, for whatever reason. And so, what judge be talking to my boss and telling him, and he goes, well, you know whose fault that is? I was like, what? The judge, I just told you. He's like, no, it's your fault because you didn't brief the judge on the state of the law and things like that, just classic. It's always my fault. But no, he would literally say that to us. And I think it was true. It's like, just go in, like, particularly for these big cases that you do have time to work on, make sure that those issues are something that you're going to put in front of the judge ahead of time. And that's not the only advantage. The other one that you have down there is advising the witnesses. So, hey, you cannot, I just had victims who often wanted to say, well, he did X, Y, or Z or something. Like, you cannot talk about that. I know he's an awful guy, and I know that's why we're going after him, but we've got to keep this within the lines because the judge has ruled those things are unfair for whatever reason. And so we're sticking to this, and we don't want to have this case come back for a bad reason. So that is also another huge advantage, is making sure all my witnesses know, can't touch this, can't talk about it.
Mm-hmm. Yeah. I mean, that's a hard one. And I don't think there's only so much wrangling, but, in combination with pretrial strategies, in combination with good preparation, you're going to, hopefully not have that torture of having something come back on appeal or have a mistrial and have to bring people back in. And of course, there's just so many reasons why we want to avoid that. So being able to advise them, not like in the hallway,
Right.
in the middle of trial, but like actually as part of the preparation.
Exactly.
So when we talk about sexual violence cases in particular, because I like your idea of this being regular practice. I'd almost envisioning a list of pretrial motions that I'd want to have in my head. Okay, I'm ready. I'm prepping this case. I want to at least think about or file this type of motion, this type of motion, this type of motion. Which are some of the ones that you would say, okay, I've got to think through the following?
So in a typical sexual violence case, it all begins with the investigation. And what are we looking into in these cases? Anytime you get a complaint of sexual violence, I'm really interested in whether this is the first time this individual has been involved in a complaint like this. And so I want my investigation to involve that. And usually working closely on the sexual assault response team, the SART, with our experienced investigators, they knew to do that. And sometimes they come up with stuff and sometimes they don't. But that's one of the things that I'm going to think about, a 404B motion, those other crimes, other acts evidence motions, because not everything that I want to get into evidence may be a crime. So just running a record and seeing that, nope, he's not got any prior accusations or convictions related to sexual offenses, that's not going to cover it. What are some of the, he's had these associations with folks where he goes to a bar and he preys on women who get intoxicated regularly. That's another act thing that I may not appear on a record. So I'm looking at that, and I'm looking at a 404B as a big part of my checklist of motion to think about when I'm filing, when I'm thinking about what am I going to do proactively in this case. An expert witness is another one. that, you may not do that in every sexual violence case, but a big strategy in my sexual violence case is, how am I going to educate the fact finder about how sexual violence works? That's what makes these cases, that victim response to the trauma of sexual violence, sets these cases apart from other cases, and why we often say, hey, if you're going to try this case like an auto theft or a burglary, you're not going to have a ton of success. These cases are different, and educating that fact finder, strategizing about how to do that, is a key. So putting on a motion to have expert testimony about the victim's response to the trauma of sexual violence may be on my checklist that I should be thinking about. I may have other strategies to educate the fact finders as well, but that might be a key one.
And your 404B, and that idea that it starts with the investigation, because you are going to have these cases where you're going to run a criminal records check and it's going to look clean, but like doing the deeper dive, looking at maybe even protection orders, employment, school records, you're going to usually find something. And I'll highlight again our work with the Sexual Assault Kit Initiative, or the SAKI project, because that has taught us, as we're actually testing these backlogged rape kits, the extent of serial offending that we see, and crossover offending, and also sort of the offending that starts with maybe loitering or burglary or peeping Tom offenses and keeps going. Those are types of things that we aren't necessarily handed us to on a platter, but could be so effective in that character evidence, and 404Bs under that umbrella of character evidence, to highlight it. In a lot of states, you'll have even a particular carve out that says propensity evidence, which normally wouldn't be admissible in 404B. You might have a statute that says, in sexual assault cases, because of all this research and because of what we know, you are able to present that. And then that's even a lower sort of hurdle that we have to go through if you live in one of those states.
Yeah, as one of our colleagues, Patty Powers, always says, 404B is a rule of inclusion, not exclusion. So we're going to bring these things in under 404B. It includes these other purposes. If you have a propensity statute like a 413 that allows prior evidence of sexual assault to come in, that is an improvement. That makes it easier to get that evidence, that relevant evidence in. If you don't, then you don't give up. You also have an opportunity under 404B. But the other thing that what you were talking about makes me think about is the SAKI kit and the number of serial offenders that were connected once these backlogged kits were tested, is that our investigators got to be on the same page about collecting and processing that evidence. If it's an intimate partner sexual assault, you might reasonably say, well, what's the point of processing this? They're married, of course they're, or they're dating, of course they're going to have sexual contact, or the defense is consent. So he's admitting it. So why do we need to send that off? You do need to send that off because it may connect to an unrelated case. And then now you've got even more evidence to bring in. And it just supports what the victim is account of what happened is. So it's one more independent piece of corroboration in these cases that the defense loves to characterize as he said, she said. It takes it out of that category almost instantly.
And I think as part of this series, we have some other opportunities where we're talking about exactly that. And I feel like in my case, when I was prosecuting, we often, and sometimes it was a matter of like, oh, we're not prioritizing this because we know the defense's consent, it's intimate partner. But when it came to trial, my jury didn't care about that.
Right.
My jury was like, you didn't do a basic step that you need to do in your investigation. And it was just, the defense had just a field day. And as much as I was like, it doesn't matter, he said it, it was still, it was a great argument for them to make. And I had nothing to say about it, which is like, we didn't test it, it's a really tough place to be. And then because of the research that's coming out of that project, that's even more reason that we should be testing those kits, no matter what the defense is, no matter what the relationship is. They need to be tested. They need to be processed.
Yeah, I just think that's so true. And that point about the defense hammering away at this was a terrible investigation.
Yeah.
it is something that is going to happen more and more and more. So that it just do the right things the right way every time. And then we've done it all. And then we have a much stronger case that's much more defensible.
I just want to say we went on a little bit of a sideline, but Patty Powers would be very proud of us.
Who was our lead on the Saki project. But
and actually Patty and I talk about DNA on another part of this series, and we're gonna say that multiple times as we talk about the foundations of sexual violence prosecutions. It's key. So the other ones here that I wanted to kind of maybe pull apart as we go through it is that the character evidence, of course, is sort of the bad character evidence of the offender, but we also might want to be proactive in keeping out irrelevant and material information that we think the defendant's going to try to introduce about the victim in the case, especially if they are known to one another. And that can be part of rape shield as well. So we want to be thinking about that. And those are more protective motions. And then, of course, there might be some discovery motions that are part and parcel of your case. I do a lot of work on cases involving immigrant victims of crime. And so you may be working on a case where the victim was undocumented at the time of the assault or was here on a student visa, and they're now applying for relief under our U visa system, which allows for crime victims to have some immigration relief. And so that might be some big issue in your discovery process. So you might want to be, out in front of that. Other things about digital evidence more and more, defense attorneys trying to, get access to victim cell phones, victim social media. So being proactive about that might be helpful as well. So
I agree 100% with that. And just like a good tip, a rape shield motion is typically something we expect the defense to file when they're seeking to introduce some evidence that is typically prohibited under rape shield. And there are exceptions. And so the typical protocol is that they file a motion and then we argue the motion. If you're coming close to a sexual violence case, trial dates a few weeks before, you might want to proactively file a motion in limine saying, hey, they haven't filed a rape shield motion. Therefore, we're going to ask that they be ordered not to question or bring up evidence relating to the victim's past. And it's just sort of a shot across the bow to make sure that the defense is following the protocol. So if they do have some evidence that they're seeking to get in, they're going to be put on the spot to say, oh, wait a minute, we do. And now I'm ready and I can prepare my victim and strategize, or even argue at that point to keep it out if it's not relevant or goes past rape shield or doesn't pierce rape shield by one of the legitimate exceptions. So just something that we want to think about and then the other character evidence too is such a great point because it's not always rape shield. It just is, hey, we're going to trash this victim any way we can. And so we're going to try and bring in things that just are irrelevant. And so we should be on guard to argue against the admission of those pieces of evidence that don't advance the case. And they're subject to the same rules we are, right? So if something isn't really relevant or it's just so unfair that the probative value is far outweighed, it doesn't come in or the judge can keep it out. We got to convince the judge that that's the case. We're under that same rule, so are they.
And I just felt like generally, and because of the way the system's set up, like defense attorneys were not held to the fire like we were. So if there's a notice requirement on rape shield and they don't give notice, but in the middle of trial, they want to enter it, more often than not, my judges would defer and be like, oh, it's okay. But if you do it proactively in advance, then there's no excuse like, oh, I thought we filed that motion or it just came up. No, you were put on notice in advance and we talked about this and you were explicitly told X, Y, and Z. And that makes it a little bit harder for them to sort of just in the middle of trial, be like, oh, well, no harm, no foul. Let's just put it in. And because we know, a tie goes to the defense sometimes.
Yeah. And it takes away our ability to brief the judge ahead of time on the state of the law. I had many cases where we had rape shield hearings in the middle of trial. Yeah. So the jury is excluded and then we go right into the rape shield hearing. And I get the judge is really I want to make sure this defendant has a fair trial. So they're gonna struggle against saying you missed the notice requirement. Therefore, I'm going to keep it out. I mean, that's a tough thing to ask a judge to do, but it is strategic, I think, on the part of defense and puts us back on our heels and makes it a little tougher for us to respond effectively or as effectively as we can if we bring it up ahead of time.
Yeah, exactly. Okay, so when we talk about character evidence, we're really talking about 401, 403, and 404. So obviously in the admission side, we're talking about, like you said, we're by the same rules, right? We're looking at what is relevant, what is material, and it needs to be admitted under a proper purpose. And on the opposite side of that, we're talking about irrelevance and immateriality and improper purposes. And then, like you said, even if it's relevant, if its probative value is substantially outweighed by a danger of one of the following: unfair, prejudice, confusing issues, misleading the jury, undue delay, wasting time, or cumulative evidence, then the court may also exclude that. So I'm trying to think about sometimes where this worked. I often would have cases where the victim and the defendant were known to one another on some level, right? Let's say shy of like intimate partner, but maybe colleagues, or ran in the same social circles, or maybe they just even knew each other for that evening. I did often find like the defense was just trying to get anything in that could shine a negative light on the victim. And so I would go through the evidence and I would just try to figure out, okay, how is the defendant going to see this, right? Let's say they got a certain amount of text messages or something like that, and you could see she was, texting multiple men flirty pictures or sending somebody a flirty photo. Like they would want to bring that up. And it was oftentimes, we weren't doing this pre-trial, and in the middle of the trial, a picture gets shown to the jury and says, didn't you send this to 2 other men the same week you met my client, or something like that, right?
Right.
And yeah,
it's the classic thing that you cannot do or should not be allowed to do under either rape shield or just, Rule 403 says even relevant evidence can be excluded if it's going to be, wildly unfair. And you're right, typically, and I think it goes back to because we don't do motions practice proactively, that most of the case law applies to or is representative of things that the prosecution is trying to do, that the defense is trying to keep out. And of course, I mean, we don't want to cross that line, but we do want to fight hard to get the relevant evidence in of the defendant's guilt. And so we want to make sure that the judge is up to speed on what is allowed under 404B so that he doesn't make a bad judgment, and what is not allowed under 404B so that they make good judgments for both sides, right? I mean, sometimes there are things. Have you ever had a judge who they made the ruling and you wish it had gone the other way, but it wasn't a ridiculous ruling, right? It was these are close arguments, and he's keeping, he's calling balls and strikes and making sure that the game is played fair. So those are important things. The cumulative evidence was the one that I often saw the defense, and it was always character witnesses. Like, it's like the least probative evidence of all. And we have 15 character witnesses for the, and our judge was like, all right, pick 3, your best 3, and that's it. Because we're not going to have this go on and on. It has nothing to do about whether this guy raped this individual or not. I'm sure he goes to church.
Their 2nd grade teacher, John.
Exactly. So, yeah.
So this is kind of the arguments for admission, right? So sometimes it's an element of the crime. Sometimes we're trying to provide something contextual. And then sometimes it's like you've got the propensity evidence statute and it's admissible under that. But I want to talk more about like the bottom 3, John. I think the motive, intent, like how do you articulate some of the 404B evidence, neatly of like, this goes to show motive or intent? What are the connections that you're trying to draw?
Yeah, so I think that the evidence of things that folks have done in the past is what's going to drive those arguments. Also, don't get tied down to arguing one theory of admissibility for this, because it often is several things. When we think of 404B, I think most people default to it is a signature crime. It's a common scheme or plan. And sometimes you get that, but honestly, that was not what I mostly had. That was on occasion we would get that, but it was more things that had to do with something the defendant did that doesn't make sense, except that it was related to his intent to commit this crime. Might be evidence that on multiple occasions he's offered women a ride home from a bar, but didn't take them home. He took them somewhere else first. So this happens regularly. And so you're suddenly realizing that, okay, that's not a crime, but it is part of how he commits this crime. It's the precursor to this assault that he regularly engages in. So it not only shows that planning, but it also shows that intent. That this is what he does before he assaults women.
And opportunity.
And opportunity. Yeah, because that is I go to this bar regularly. That's just one example, right? It could be lots of different things that folks engage in, and we want to keep our eye on that and make sure that those prior incidents that, sometimes it's something that looks potentially routine or innocent, but when you put it in context with all the other things that the defendant engaged in and the complaint of sexual assault in this case, then it becomes clear this is part of that scheme or plan. So we have to make sure that both investigators and prosecutors are looking in at the evidence with clear eyes, because if we don't find that evidence, if we don't look for it proactively and recognize it for what it is, we're never going to get it in for the jury to hear. We'll never be able to make that argument.
Yeah. John Kurland, another one of our colleagues, and I talked about the sexual offenders like perfect plan. We talked about, accessibility and vulnerability. And I think you could look at that perfect plan and also articulate all the pieces of that being 404. Like, where are they? What jobs are they having? Oh, they're an Uber driver. They're working in schools. They're working on college campuses. Like anything that you are kind of in your head using to build out, this is the defendant. This is who this defendant really is. This is how they've put themselves in a position where they can have the motive and the opportunity, the intent. Now, all of those things can then be argued for admission under that as well, under lack of consent as well. And then the one thing I want to highlight before we move off of this is that we often, I even catch myself saying it, like prior bad acts, but it could be subsequent bad acts as well that can go to things like consciousness of guilt.
Yeah, no, I think that's so important because people will do things after they're charged to evade accountability. Particularly, as you mentioned, the vast majority of our cases are individuals that know each other in some way, shape, or form, from someone you just met at a party, at a bar, at anywhere, to an intimate partner. They're offenders across that spectrum. And so depending on that relationship, people might use things to make it more difficult for a victim to participate in the investigation or prosecution of the case, which is already hugely difficult for victims, period, regardless of the relationship to the individual. The small minority of our cases are stranger rapes, but it's difficult for people to come forward, period. So anything they can do to make it more difficult, they're going to do. And so we want to identify those things and argue to introduce them into trial as consciousness of guilt, because who would do these things unless they were guilty? Who would try and make it tougher on the victim? Who would threaten to reveal something of an intimate nature about the victim if they weren't trying to make that victim go away or harass them to the point that they would make a decision that it's better to drop out of this case than to go forward in this case. So we definitely want to keep an eye on that and make these motions. You may not win every motion, but it may also, shining a light on that behavior may arrest that behavior, whatever that offender is engaging in after charge, prior to trial, trying to make that victim go away, because it isn't going to end. And then there's retaliation afterwards too. So even after trial, regardless of the outcome. So we need to keep a clear eye on that.
Mm-hmm. And because of the fact that there are this known offender is the majority, you may just have like I don't know, just bad mouthing in the community. They're putting out their little campaign to
Yeah.
make it uncomfortable, to do some sort of third party harassment, sort of like get their forces behind them. Especially I'm thinking about like either in a small community or like a college campus where there's just this kind of rumor mill that they're then taking advantage of to, like you said, well, you were very arrest that behavior.
No, we had the same thing because we're a small town. So everybody knows everybody. They're doing that campaign. We had a college university in our town. So that happened. Military base not far. That was another micro community where these things would happen. Just people in tight knit neighborhoods, the same thing. It becomes very difficult. People take sides. Offenders plan information, drive these campaigns to make it tougher on the victim. And we should be aware of that and identify and use that information at trial when we can.
So this is one of my tricks, John, when I was like writing pretrial motions, is I often went and looked at the advisory notes of certain rules or like the legislative intent behind something. And it would give me a lot of good arguments about the public policy behind whatever I was trying to kind of push forward. And so this is the advisory notes of the Rape Shield federal statute, which has great language in it that I would use in my motion because it says, we want to safeguard the alleged victim from an invasion of privacy. This language would be key in discovery motions as well. If you're responding to the court has recognized that there's a legitimate aim here to safeguard the alleged victim against invasion of privacy, potential embarrassment, and sexual stereotyping that is associated with public disclosure of intimate sexual details, sexual innuendos, and into the fact-finding process. So it's a great way to kind of ground why we're making these motions and what has been acknowledged by our lawmakers as an aim of the work that we're doing.
Yeah, I also think that's super helpful when you have something that doesn't fall squarely within Rape Shield, but you have the public policy from the advisory note that would apply equally to something that's just outside Rape Shield. And just look,
Yeah, when you're trying to kind of expand it.
Yeah, or just keep something unfair out. It's unfair, and this is the basis for all the Rape Shield legislation. And this is also unfair. And maybe it's you identify a previous victim of the assault. And does your Rape Shield statute have language that covers a previous victim or only the victim in the current case? And can we make an argument that they wrote it this way, but clearly the intent is to protect victims from these unfair invasions of privacy?
The spirit of the rule. We had to use that, and I know people across the country are using it in trafficking cases because Rape Shield doesn't explicitly, ours was enumerated to what kinds of crimes it covered. And, I think we're now realizing that was probably overly restrictive. But we're like, okay, it doesn't fit human trafficking. That's not one of the, enumerated offenses.
Right.
This is the spirit. This is what we're doing. And we're using that. And so again, when we're looking at discovery or improper discovery requests where we're getting hit with motions to compel and subpoenas often aimed to get to some of this improper evidence or improper information, where they're trying to say, well, let me just look at the victim's entire social media history. Let me look at their entire cell phone, because I'm sure if I dig deep enough, I'm either going to harass the victim and make the victim so uncomfortable that they don't want to be part of the process, or I'm going to uncover something salacious that I at least deem salacious and I think I can exploit in front of a jury. And so we see that a lot. And so I think this is probably one of my most common requests for help from prosecutors are these emerging motions, and the judges are, it's novel and they're like, okay, they want to make sure the defense has a right to a fair trial, but we need to remind the judges, like, let's step back and think about what are the foundations of our discovery rules, right? So we've got our statutory discovery rules that usually only say, the defendant has the right to evidence that is relevant, material, exculpatory, and sometimes it also says can lead to other relevant material, exculpatory evidence. So that's our statutory rules. I think we need to ground there. Most statutory rules now include the Brady and the Giglio language, but if they don't, we have to make sure those are our due process obligations. And then we have to think about, okay, what is in our care, custody, and control? The victim, are they a party to this case technically? No.
No, I think that's super important. And thinking about all those things is going to be really helpful in arguing about discovery requests. I honestly don't blame the defense for, like, I would want as much as possible too. So that they're going to throw a blanket thing out there. It's our job to make sure that it gets reined into what the law allows and what is fair. And so we have to make those arguments to the judge. So the care, custody, and control, as you're pointing out, is another great one to think about. We are deemed to be in custody of information that the police know. So we want to make sure that they communicate or they send us everything that they have. So we have it all to turn over. There's no trial by ambush. But we're not in care, custody, or control of other things that have nothing to do with the case. Yeah.
And so I'm thinking about this one case where, a pretty skilled defense attorney whose background was as a prosecutor trying cases of cybercrime cases. And so it was just really, I think, taking advantage of the fact that the judge was not really comfortable with digital evidence or with social media, and had convinced the judge in a case that the victim needed to provide their cell phone every 6 weeks to the defendant to have it downloaded. In case the victim ever said something, text message somebody, something exculpatory. I mean, that was how
crazy.
I mean, I want to say it's crazy, but it was the defense made it seem like so scary that this phone could contain exculpatory evidence and he wouldn't have access to it. And it was an ongoing obligation as well on behalf of the victim. So we had to, threaten some interlocutory appeals. We had to because the court ordered this.
Oh, yeah. I mean, why didn't you just say they have to identify every person they talk to?
That was part of it. That was part of it.
Every person but it's because they might have talked to the person at McDonald's about their case. So it's just, no, that's crazy.
But I think that happens, especially when it comes to digital evidence. Judges aren't given a lot of training on it, and they're also sort of actively disincentivized from engaging in it.
Yeah.
Right. So then it's a little bit more uncomfortable for them. So that's something that we see a lot. Victims are not subject to discovery. And in fact, in some of these cases, you may want to even provide victim access to an attorney because they may need their own counsel if it's going beyond something that you can assert on their behalf. And of course, a lot of states also have bills of rights that talk about right to privacy, a right to be free from harassment. So those are also public policy arguments that you can weave in here. But we see that quite a bit. And then when we are, kind of providing discovery on some of these issues, and I think, for good reason, a lot of offices have these open file discovery, or in Florida, we called it sunshine discovery, where hey, everything I know, and that's our default. It's a good CYA, it's general practice. It's you can know everything, and then I'll litigate it out later. And I think we just need to rethink that when it comes to our sexual assault cases, and maybe be a little bit more proactively protective, because the ramifications, the chilling effect on victims. If you are a victim of sexual assault, and because of that victimization, that means you have to turn over your entire cell phone and allow me to go through it. I'd tell you, I would think twice. Right. I wouldn't want somebody access to my whole cell phone, all the information that it has. So we just need to take a little bit of a different tact. I mean, obviously, ethically protect their privacy, but just hold the standard of, is it relevant? Is it material? Is it exculpatory? Or could it lead to anything? And if not, we're going to redact it. Right. And be really clear about what's being redacted. So if the defense has an argument about why it shouldn't be redacted, they have an opportunity to make that argument. So they kind of have to know what they don't know a little bit. You don't want to hide the ball. We can also use things like protective orders. And then the last one being, okay, well, maybe the judge will make the call and ask for an in-camera inspection. So we've got strategies there.
And this also goes back to investigation as well, because if we avoid having something not avoid, but if we don't need to have something in our care, custody, and control, then let's not have it in our care, custody, and control. Just let's get what we need. So, I don't know how much it matters to the victim that the defense is not going to get to see the contents of their phone. Anybody gets to see it. I just wouldn't want anybody to get to see it. So if we can not have that in our care, custody, control, let's just get the relevant stuff and make sure you get enough so that there's context and the defense sure that you got everything that's relevant. So it might be, we need this text chain to go to one text beyond what we want, just to demonstrate that.
And I love this screen recording feature, because you can record it and scroll through it. It's much less likely that defense can make good arguments that you're hiding the ball or you're cutting and pasting. And collaborating with a victim attorney at this part might be a good thing to do. But I want to get to the expert witnesses, because you mentioned that's one of your go-tos. And I agree so much. And, this is the federal rule. Almost all states, it mirrors this. And I always like to point out two things, and I'm sure you probably know it, John. One is who's qualified, and to know that you can be qualified through knowledge and experience and training. It's not necessarily a bunch of letters after your name. And then also, it's not just a technical or scientific knowledge, but it's any specialized knowledge. So I don't know who you used to like to use, but I would use like the victim services. I loved having them as my experts.
So just being part of a SART, you just realize very quickly, because they're educating me. I was just like, these victim service providers are community-based advocates. They know how these crimes work. They know what victims go through. They know how victims respond to this trauma, and they're explaining it to me, so they can explain it potentially to a jury. Although no advocate that I typically meet ever considers themselves an expert, or we go.
They're
around.
humble, John.
Exactly. But I mean, I guess we are experts too, but whatever. We don't typically think of ourselves. We just have a lot of experience and a lot of knowledge, and we try and share it with people. And that's really what this expert's going to do. They're not going to weigh in on the case. They're just going to educate people about how these crimes work, so that the jury or the judge doesn't make a bad credibility decision.
Yeah. And these are like social sciences, sometimes soft sciences. And so one of the issues that comes up all the time is, how do we make our arguments under Daubert or Fry, which are clearly written for more scientific type evidence that could be, replicated in a lab. And that's not the kind of science we're talking about. So here's a couple of cases that specifically say these kinds of experts require a different type of reliability test. And really the judge has a lot of determination on that. But we may need to use it. I wanted to ask you before we move on to this piece is what kinds of questions, because I would always use my victim services. I would call them prepping for a case. I have this weird fact, what's, if a victim did this, what might be going on? And they'd always be like, actually, Jane, that's super common. And I'd be like, really? And they're like, yeah, that happens more than you'd think. And this is some of the reasons why. And I'd be like, oh, okay. And sometimes I felt like, I don't know if I could ever get a jury to get there, but I at least felt like, okay, I have a legitimate strategy to do that. I understand it. I definitely, you can't get a jury to understand it if you don't understand it, and then kind of strategize about, okay, how am I going to talk about this? And the victim services were just, so valuable.
Yeah, no, 100%. That's exactly how it works. I just feel like if you're not working closely with those folks and don't have them as a resource, you're really not taking advantage of all the resources out there to move these cases forward. Because I just often would make siloed decisions about cases and credibility and what I think I can get a jury to understand. And these folks have a lot to bring to bear on that question. And so I definitely think we need to take advantage of that. Experts aren't just for trial, they're for every aspect of the case. And they're going to help us improve not just how we win cases or try cases, but how our system responds.
Mm-hmm. And so we've got some other novel issues that often will need briefing. And I just want to plug AEquitas here because the expert witness issue, we have done so much work across the country. We probably have sample motions. We've done state-specific research. Some of y'all are in states that have, a long history of allowing this type of evidence. Other places you're going to have to maybe make that novel argument. So reach out to us. Do not reinvent the wheel. And the same goes to some of these other novel issues that I could expect might come up. That immigration-related evidence I talked about with the U visa, digital evidence, forfeiture by wrongdoing may come up when we've got that level of witness intimidation, image exploitation. There's some brand new statutes where there's no jury instructions yet. There's no case law. How are you going to make that argument there? And so that might be important. And again, reach out, don't reinvent the wheel, but think about how am I going to brief it? How am I going to argue it? And how can experts help me get there?
And we also do training for folks that want to testify as experts. And so that's a great training where we go over what ethical testimony looks like, the law in your particular jurisdiction, and then mock testimony or demonstrate a good expert testimony. And so that's another thing that I think we can help folks with if they're interested.
Yeah, that's a fun one to do with prosecutors and would-be experts.
Yes.
Hearing the same thing at the same time, working together.
Yeah.
So hopefully you're walking away from this series, listening to John and being like, okay, I need to be more intentional about my pretrial motions, and be thoughtful, need to really be thinking about it as a tool to educate, and then focusing on how am I going to protect my case and the victim so that I can better hold the offender accountable. So John, I really want to thank you. Lots of other resources here. Thank you for being with me today. This is your information, and we'll talk soon.
Thanks, Jane. This was great.
Okay, I'll talk later. Bye.
Bye.